In the chapter that's coming out in Jack Ataev's book, Handbook of Police Psychology, I wrote a chapter entitled Principles of Fitness for Duty Evaluations for Police Psychologists. And in that chapter, I articulate 15 principles that I believe should guide a police psychologist in performing fitness for duty evaluations. And so the rest of my presentation to you this afternoon and tomorrow will be on these 15 principles and walking you through them. I've added some additional data or additional slides naturally to the ones that you have, and all of those, as I promised earlier, will be made available to you. So let's talk about the first principle. Okay. So in general, we know that the ADA regards the employer as having met the business necessity standard when the employer has objective evidence that, number one, an employee's ability to perform essential job functions will be impaired by a medical condition, or two, an employee will pose a direct threat due to a medical condition. Those are quotes from the EEOC Guidance, excuse me, the EEOC regulations. Said another way, the law requires objective evidence of performance or safety threats and a known or reasonably suspected mental condition. Gold and Schumann have a book they published in 2009 on evaluation of disabilities in the workplace. Excellent resource. I really encourage those of you who do fitness for duty evaluations to read this book.
Say it again.
Gold and Schumann, S-H-U-M-A-N. Daniel Schumann, by the way, is the Daniel Schumann of Stu Greenberg and Daniel Schumann fame, where they wrote the article on when worlds collide, conflicts between clinical assessment and forensic testimony, and the roles, the conflict between clinical and forensic roles. So Daniel Schumann's an attorney who specializes in mental health law, and Gold is a psychiatrist, I believe.
What's the name?
Pardon?
Name of the book?
I don't remember the name of the book.
The article is, I think it's like irreconcilable differences between...
No, he's talking about the book.
Oh.
Evaluating mental health disability in the workplace.
Evaluating mental health disability in the workplace. Perfect, thank you. Good book, isn't it?
Yeah, it's great.
Yeah, it's a great book. Okay, so so Gold and Schumann wrote, one of these, that is, objective evidence of performance problems or safety threats, and a known or reasonably suspected mental condition, one of these in the absence of the other represents an insufficient basis for a fitness for duty examination.
What?
One of these in the absence of the other represents an insufficient basis for a fitness for duty examination. So when an employer calls and says, I want to do a fitness for duty evaluation because the person was crying at work, crying in the briefing room. Okay? I understand why they're concerned about the person's emotional stability. If I hear what sounds like hoof steps outside my office, I could think horse, or I could think zebra. If it's going to be a four-hoofed animal, it's probably going to be a horse in Oregon. But in order to make the assumption that it's going to be something else, I need more information. What kind of information do they have? Well, what would be the first thing that an employer ought to do? Ask the person why they're crying. Maybe they had a death in the family.
Maybe they got something in their eye.
Maybe they got something in their eye. Any number of things could be prompting the behavior. So the first thing you want to do is ask, so Yeah, how about after that? What happened? What did they say when you asked them? Well, we didn't. We just thought we should probably refer them to you for a fitness evaluation. Well, I say what? Let's try this first. So the first thing you want to do is assess how the employer met the legal threshold for mandating a fitness for duty examination. Is it possible that the employer is trying to get rid of an employee and to use the fitness for duty process to do that? Is that possible? Is it possible that the employer is retaliating against the employee for some lawful but annoying act on the part of the employee? Yes. So the question you have to ask is, what's the reasonable basis for expecting that the behavior that they find problematic derives from a mental condition? So, first part is, what's the objective evidence for their concern? Second part is, what is the basis for believing that there's a mental health condition that explains or contributes to or underlies that behavior? Now, this isn't just an effort to keep the employer from harming their own interests or for violating the rights of the employees. What are the other values that you gain from understanding the objective basis for the referral and the extent and how they have justified the legal threshold? What are some of the other advantages? Well, it keeps you out of court. Because if in fact it's retaliatory, there's a good chance you're going to wind up being a party. That's exactly what happened with Eric Ostroff. Eric Ostroff found the police officer, the plaintiff police officer at McGreal, he found him fit for duty. I mean, this isn't a matter of he found him unfit for duty and he lost his job. He found him fit for duty. So he got engaged in this because the evaluation should never have gone forward in the first place. There was no objective basis for the referral, or I should say an inadequate one. Certainly there was an objective basis, because the guy had made a lot of complaints about the mayor. He was a real difficult person. He had believed that there were some conspiracies going on between the mayor and the police chief and the little town of Alsap. And there may well have been, who knows, I don't know. But the court ruled that there was no legitimate basis for the fitness for duty evaluation to begin with, and everything else after that began to fall apart. So, one is it helps reduce the likelihood that you're going to wind up enmeshed in some very difficult and costly litigation. Second is, if it does go forward, you're in a much better position to define the scope of the evaluation by understanding what is the behavior. How did the wheels start to fall off the wagon? When did they start to fall off the wagon? Is this new? Is this old? So this is what we might call the pre-referral conference. Remember I said earlier, an agency calls my office, wants to schedule a fitness for duty evaluation. They don't get to do that. They have to talk to me first, and I want to hear. So what is the behavior that gives rise to concern? Now what if they say, well, the person has just been turning in reports late, chronically. We had to drop prosecution on a number of high-profile cases because the person didn't get their reports. Oh, there's a lot of possible explanations. Rand?
Wouldn't the standard be to ask, and how has the agency responded?
Absolutely. The question is, wouldn't it be standard for me to ask, and how have you responded? It's absolutely standard for me to ask, and how have you responded? Because if they say, well, we haven't done anything yet, we thought we'd call you and see if maybe you could help. Well, maybe I can, but let's start with you calling him in and asking him. There's a very, very good likelihood, if the behavior is problematic behavior, or if it's alleged to be behavior that could potentially lead to disciplinary action or termination, that I'm going to say to the employer, have you done or are you doing an internal affairs investigation? They go, well, we haven't done that yet. We thought we'd start with the fitness for duty evaluation. How about let's not? How about you do the internal affairs investigation and then provide me with your findings? That way I have objective information that will aid me. Because if I call the person in and I start asking them questions, I don't know what the truth is. I don't have any ability to discern the truth. I don't know what really happened. Secondly, is there some possibility that you might do the internal affairs investigation and determine this person's behavior is so egregious, we're going to terminate? Is that possible? Yes, that's possible. Then you don't want to do a fitness for duty evaluation on a person you're going to be firing anyway. It complicates the issue. Third, how long is it going to take you to do the internal affairs investigation? I don't know, man. That's part of the problem. Is it could take 2-3 months. Understood. Could be more. Yes. So what value is a fitness for duty evaluation I conduct today if you're not even returning the person to work for 4, 5, or 6 months? Wouldn't it be more appropriate you do the internal affairs investigation, determine you're not going to terminate, but you are going to discipline, and one of the conditions of returning to work is a fitness for duty evaluation. I do the fitness for duty evaluation, and if I find the person fit for duty, they go to work. Yeah, you're right. That would make more sense. And you hear, of course, this sigh of, dang, I thought it was going to be easy. I thought you were going to do the fitness evaluation, and you were going to find the person unfit for duty. The other part is an educational process that I need to have with the employer. So let's be clear, and we're going to talk more about this in one of the subsequent principles. Let's be clear about how fitness is defined, or more appropriately, how unfitness is defined. And we're going to come to that one in a moment.
They do the IA, determine there's going to be discipline, and before the discipline, they send it to you.
Well, it's often the case that an IA investigation is done, fault is found, there's a recommendation for disciplinary action, the chief determines that a fitness for duty evaluation needs to be done, and decides that before making a final determination about discipline, he's going to have a fitness for duty evaluation. And why might that be relevant? Why might that be appropriate? Can you think of any reason?
Sure.
Mitigation.
Mitigation.
Might it be appropriate for a chief to say, look, if this person's behavior resulted from his undiagnosed, unnoticed, untreated PTSD that resulted from a shooting he had 3 years ago, I want him to get help.
I want to punish him.
I don't want to punish him. We'll put him on notice that this is a free pass this time. It's documented. He'll get some counseling, but I'm not going to suspend him. That might be the chief's decision.
I think what I'm asking is, at what point is the fitness for duty evaluation perceived by the employee and his attorney as punitive?
The question is at what point does the employee and the employee's attorney see it as punitive? It could be immediately that they see it that way. I'm not worried about that. I do a lot of fitness for duty evaluations. I work very hard to establish an objective role, that I'm not engaged in retaliation. Whether or not my work gets misused is something I need to be mindful of the potential for and work very hard to prevent that from happening. But I think more often than not, people come into the fitness for duty evaluation with one attitude when it starts out, and they have a different attitude when it ends. Sometimes they don't. They're absolutely as upset throughout and after as they were at the beginning. I'm not going to pretend otherwise. But I can't be responsible for it. One of the common introductory conversations I have with an examinee in a fitness for duty examination is I say this. There are 4 possible scenarios resulting from this evaluation. One is that you're fit for duty and I find you fit for duty. That is, you really are fit and I conclude that you're fit. And they're going, yeah, I like that one. That's the one we want. Let's go over that scenario. Oh, great. Me too. I would like that if that's the case. Option 2 is that you're unfit for duty in reality, and I find you unfit for duty. I don't like that. I know you don't like that one, but let's assume for a moment, but I am fit for duty. I understand, this is just one of 4 possible scenarios. Hold on. Okay, yeah, you're right. That's a possible outcome. I said, now both of those, let's just say, let's call those accurate. Right? You really are fit for duty and I find you so. You're not fit for duty and I find you not fit for duty. Those are both, in the scenarios I just laid out, they're accurate conclusions. Right? Right. Okay, let's just set those aside. Now there are 2 possible inaccurate outcomes. Now let's agree from the outset, we want to avoid an inaccurate outcome. Agreed? Absolutely. Good. We're in agreement. Here are the 2 possible inaccurate outcomes. You're fit for duty, and I find you unfit. I don't want that to happen. Neither do I. Another possibility is you're unfit for duty, and I find you fit.
I'm okay with that.
Okay. Now, of those 2 possible scenarios, which one is least in your interest? Honestly, you would be surprised at this. 9 times out of 10, they say the latter. The latter is the least in my interest. And I ask, just to clarify, make sure they understand it and get it, and why is that? They'll say, well, because if I'm really unfit and I go back to work, somebody's going to get hurt, or I could get hurt, or I'm going to get fired eventually. Exactly. Exactly. Now let's just take the other error, the other inaccurate outcome. You're fit for duty, but I find you unfit. What's likely to happen? What's the worst case? Oh, they'll fire me. Now, that's really unlikely. I suppose it is the worst case, but it's unlikely. That's not the way these things come down. You have vacation, sick leave, FMLA available? Yeah. So here's what's going to happen. If I find you unfit for duty, you're going to be placed for a period of time until they make a decision. You're going to continue unpaid administrative leave. That's the way it happens. And you know, with your agency, God knows that could be weeks to months. Eventually, they're going to make a decision about what to do with you. And then they're going to take you off paid administrative leave, and you're going to go on your vacation time, sick leave time. You're going to have contributions to sick leave from your union brothers and sisters. You're going to go on FMLA, whatever. Eventually, if you don't become fit for duty, if your fitness isn't restored, at that point they're going to notify you that you have X number of days, and you know, if you can't get your act together, they're going to let you go. But remember, in this scenario, dude, you really are fit for duty, and I just screwed up. So that's going to happen quickly, because you really are fit, right? Right. Okay, so we don't really need to worry about that scenario. So of all the things we've talked about, the thing you need to help me make sure doesn't happen is that if you're unfit for duty, you don't want me concluding you're fit. Now, no, I'm serious. Most applicants become a partner, most examinees at that point become a partner in the process. So I say the same thing holds true. If I find you unfit for duty and you're really not, all of those things that I described earlier are still true. They're going to work with you. They want you to get your fitness restored. You're going to have an opportunity for treatment. They're not just going to fire you. It doesn't happen that way. That only happens on television. It doesn't happen that way. So that's how we begin it. But I really can't have that conversation in a very intelligent and useful way unless or until I've done a good pre-referral conference where I understand what's led to this, I've got objective data, I have the results of the internal investigation, I've received all the records, and then I'm able to do it.